SJC 12226, Christina Barbuto v. Advantage Sales and Marketing, LLC.
Chief Justice and Associate Justices, good morning. May it please the Court. My name is Matthew Fogelman. I'm here with my co-counsel, Adam Fine. We represent the appellant, Christina Barbuto. Your Honors, this case is about a woman with a medical condition that substantially impairs a life activity and the means of treatment in which she engages, which is legal under Massachusetts law, recommended by her doctor. And Ms. Barbuto should be free from discrimination at work based on her disability and the legal manner in which she treats her disability. She should not be faced with the cruel choice of treating her disability or earning a livelihood, the unconscionable choice between her job and her health. And people with severe, debilitating conditions should not be, per se, disqualified from employment. They are subject to the protections of 151B. Your Honors, we are talking about the sickest of the sick who live amongst us. We're talking about people with terminal cancer. Yes, Your Honor.
I was just about to get to that. Let's take it out of the range of marijuana, because there is this federal-state dichotomy in terms of legality, and make it something that is not recognized as illegal under either set of laws. Something like an opiate that is taken by somebody who has cancer. Could an employer have a drug testing policy that tests for use of such a prescribed opiate and fire if there were a positive result?
Absolutely not, Your Honor. Well, to the first question, could they have a drug test? Yes, if it meets the invasion of privacy standard that this Court has set forth in Webster. So not any company can drug test. If the company shows that they have a reason, such as public safety or health or welfare is involved, so in other words, a police officer, a firefighter, school teacher, truck driver, places where someone's going to be at risk. If this person, if they're unable to function because the medication is making them feel a certain way, for example, and their job is one of those jobs, then yes, the drug test would be appropriate. As to whether they could fire them, Your Honor, no, unless they could show that that the accommodation requested was not reasonable, that they were impaired at work, or more importantly, and for this case as well, that there's an undue burden on the employer. So we don't want employers injecting themselves into the sacred doctor-patient relationship. We don't want employers dictating what medication a patient can or cannot use if that medication is legal under Massachusetts law. Mm-hmm. Does that respond to your question?
Yes.
What do you do with all these cases, Washington State, Michigan, Sixth Circuit, Colorado, including one involving the Colorado Constitution? How do you distinguish all those cases?
Yes, Your Honor. Admittedly, there have been several, as you mentioned. Each one is distinguishable, and we have to look at each one. I don't know if you want me to go one by one, Your Honor, but for example...
Well, take Ross. Why don't you take that?
In California, there was no discrimination before the court. They were really looking at the Act. And here, when I say the Act, our equivalent would be the Medical Marijuana Act. I'll just refer to it as the Act. Okay. That's what they were looking at. It really wasn't a discrimination case. In Colorado, in Coates, they were looking at the definition. It was a lawful activity statute, and the court in Colorado found that the term lawful activity includes state and federal law. In another one of the cases, Your Honor, the language that we have in our Act, shall not be denied any right or privilege, was absent from that Act. So if we go one by one, Your Honor, you actually will see that there are marked differences. They either have language that we don't have, they don't have language that we do have. It wasn't looking at discrimination law. So each one is distinguishable, Your Honor.
Does it make a difference that our law only decriminalized rather than legalized marijuana? Is the analysis different?
So, Your Honor, on the Act, we don't agree that the Act is purely a decriminalization statute. However, I'm not sure that that's the ultimate question, because we have 151B protections, and the Act certainly did not in any way abrogate 151B. So when we step back and look at this really as a disability case, we're talking about a limited subset of people. We're talking about people who have disabilities. whether they have cancer, Crohn's disease, Parkinson's, etc. We have a policy, and this court has said very specifically in Dayhill, as well as in other cases, that the policy is that we want people working. We want people contributing to society. And we don't want people, obviously, being discriminated against because of a disability. A disability and how one treats that disability are inextricably linked.
What I had in mind is if the purpose of the statute is to avoid criminal penalties, which is one way to look at it, it's a very narrow purpose, and that's the only purpose, because we haven't legalized marijuana, we've only decriminalized it. So if that's the purpose of the statute, then that might suggest that it doesn't have anything to do with the employer-employee situation. The statute isn't designed to get into that relationship.
Well, Your Honor, I appreciate that. In the Act, there is specific language that we obviously refer to, and it says a couple of things. It says that no person shall be penalized under Massachusetts law in any manner or denied any right or privilege available to them under Massachusetts law. Treating a handicapped person using a medicine differently than a handicapped person using a different medicine would be penalizing them. It would be denying them a right or privilege under Massachusetts law, which is to be free from discrimination in the workplace. So it's not really about marijuana, Your Honor. It's about the person's disability, the manner in which they treat their condition, legal under Massachusetts, with a written certification from a doctor. To go and obtain that certification card, Your Honor, is an onerous process. It's not just given out willy-nilly. So we're talking about very sick people who have tried usually alternative means. And again, in the Dayhill case, Your Honor, specifically this court has talked about how medicine evolves over time. And this is a perfect example of that. So if someone is treating their condition with a medicine that is legal for them to take in Massachusetts, it would be really an unconscionable and a Hobson's choice to tell that person, yes, you can treat your condition. You're not going to be criminalized, but you can't work. What happens?
Let's step back a little bit.
Yes, Chief Justice.
Put aside the medical marijuana part. Let's go back to Justice Lank's example. Let's assume that she had some condition for which she was taking opiate pain medication.
As a lot of people do.
Pursuant to a prescription. Do you agree that it would be appropriate for an employer to generally say, we do not permit somebody to use opium, to use opium and be an employee, that they could have a generic rule that would bar it? Is there any prohibition against that?
I don't think that is allowed, Your Honor. I believe that is covered under 151B.
So I'm not saying the person has a disability. I'm saying, could they make a general rule?
So why is the person taking opioids if they have a prescription?
Well, a lot of people take opioids without a medical condition, as you know. So if they were to be testing positive for heroin or whatever else, then they could be fired. Do you agree that that would be permissible in general for an employer to say, we do not permit our employees to use heroin or opium or other opiates?
Even if legal.
With your question specifically, Your Honor, I would agree. However, yes, I would agree with that.
Okay.
When the person has a disability or a medical condition, obviously that...
Well, I'm going to go to the next step.
Yes.
Okay, so then the person comes forward and says, I want to work here. I do have this condition. It would be a qualified disability. I manage my pain with opium, and I would like to work here. Okay, what should have happened in this case? In this particular case, I gather they said fine, and then somebody undid that reasonable accommodation.
That's exactly correct. That's exactly what happened.
So what should happen under those circumstances that I've described?
Where now we're talking about someone with a disability.
Someone who has a qualified disability being managed through the use of prescription medication, which would be a controlled substance.
I think this court in Ocean Spray and in MBTA versus MCAD, which actually Justice Hines handled at the lower court, I think it's very clear. There's an analysis that has to be performed. There's an interactive dialogue. So we look at what is the person requesting an accommodation for. What is the accommodation they're requesting? Is that reasonable? And can it be provided without being an undue burden to the employer? That's the heart of this case, Your Honor, because none of that happened here. And what the defendant and what Judge Tochka allowed is a categorical, per se, exemption. That if you are using this particular medicine, you don't have to go through that analysis because it's facially unreasonable to work there. And that is not the law, Your Honor. So the answer to your question, I'm sorry to be redundant, is to go through that very individualized, nuanced analysis. And there are going to be cases, Your Honors, where it is an undue burden for the employer. Absolutely. The Beal case is an example of that. The police officer. We talked with Justice Lank. There are going to be certain industries and fields where that analysis, that calculation, is going to come out in favor of an undue burden. It didn't come out that way here, nor really could it come out that way here because of the job and the industry that Ms. Barbuto was working in.
Can I ask you a question? Are you basically accepting the view of the MCAD's amicus?
Absolutely. I think the MCAD amicus and the Mila amicus are both excellent pieces of work.
Is that they reflect your position as to 151B, I guess is my question.
Yes. And this court has given great deference, certainly, not only to 151B, but to the MCAD in terms of how it interprets and enforces 151B. I'm sorry, to the MCAD. If I said to 151B, I meant deference to the MCAD.
Going back to the hypo we were discussing.
Yes, sir.
If during the course of what you describe as this interactive discussion with the employer with regard to reasonable accommodation, would it be appropriate for an employer to say, is there alternative medication that would be equally effective which would not be an opiate?
I don't think so, Your Honor. I don't think so because, again, we don't want employers injecting themselves into the doctor-patient relationship. If the patient has a condition and the patient and the doctor have arrived at a course of treatment recommended by the physician, legally prescribed by the physician, the employer should not be inserting themselves into that relationship. And one crucial point, Your Honor, we're not talking about anyone who's impaired. If someone is impaired at work, that's a totally different situation. We're talking about off-site use, not impaired at work, able to perform the essential functions of his or her job, and no undue burden on the employer to accommodate that. Once we have those boxes checked, that person, under our laws, should be allowed to work at that place of employment.
So you're saying then that the employer's rule, in my example, barring any use of opium or heroin-related substances, would have to give way whenever the doctor would be prescribing that for somebody for a qualified handicapped condition.
I do. And many people take all kinds of medications, Your Honor. Insulin. People take sleeping pills. I mean, the number of people that take depression and anxiety pills is off the charts in the pharmaceutical industry. I mean, I don't know the percentages exactly, Your Honor, but it's a lot. It's a lot. And those people go to work every day.
To what effect is the federal prohibition?
Justice Gaziano, I would say basically none. It's certainly been debated a lot in this case. It's a soundbite, well, federal law. But when you really start to peel that onion, it dissipates. There's no preemption in the field here, and my brother's not even arguing preemption. So what we're talking about is Massachusetts law. Advantage Sales and Marketing has come to Massachusetts to do business. They didn't have to come here. They chose to come here. That's great. If they're here, state law applies to them. We had the Goodrich case before this court, before gay marriage was legalized federally. A company couldn't come here and say, we're going to fire someone because they got gay married because we follow federal law. That's not how it works. Minimum wage, you can't follow federal law. Massachusetts may have a higher state minimum wage than federal law. You're doing business in Massachusetts, you're following our law. So I would say that it's really a red herring, Your Honor, and I don't think we have to spend much time on it.
Is there any prohibition under federal law that the defendant would be required to violate?
I'm sorry, one more time, Your Honor?
Is there anything under federal law that would somehow penalize the defendant were any of the accommodations you requested granted? Is there any way that the defendant is at risk by accommodating, I guess?
I don't think that this defendant is at risk. Again, you might imagine a situation where a defendant is getting federal money or federal grants.
And that's also part of the individualized inquiry.
Absolutely.
You're saying.
Absolutely. Yes, it is.
So if it were required to maintain a drug-free employment pursuant to federal contract or federal rule, then they would not have to give way as a reasonable accommodation.
I would generally agree with that, Your Honor.
Does this last discussion underscore the problems with a 12b6 dismissal?
Yes, Your Honor. Yes, absolutely. This is, as you said, this is a motion to dismiss. We've had no discovery. We've had no benefit to engage in any evidentiary findings about what analysis was undertaken. I don't think there was any, by the way, but absolutely. And most of these cases, in terms of accommodation and undue burden, wind up being for a jury. Okay. Yes, Your Honor.
I'm all set. Thank you.
Okay.
Yeah, where's the, thank you, Chief, the implied private right of action here?
Your Honor, we do believe that this court has the power to find an implied right of action. There's been precedent for that in cases like Lafredo. I think the shortest answer I can give is that I don't think we have to go there. I believe that this case is covered by 151B.
So you have different claims, though. You have wrongful termination, private right of action under the Mass Medical Act, the Medical Marijuana Act, and handicap discrimination under 151B, right?
Yes.
So you're just only arguing about 151B now.
I am. I'm not conceding that there's possibly no private right of action. And again, I think the court, in its discretion, has the power, if it wants to go there, to do that.
But that's only under the Medical Marijuana Act that we're talking about. That's the count for that.
Correct.
Okay.
Correct. And what I'm saying, Your Honor, is that I think the easier and the more logical path, quite frankly, is under 151B, which we already have the framework and analysis for. Your Honor, may I wrap up with a closing?
Very short.
Very short. Your Honor, we're not seeking to expand the law here. We're seeking to take the law as it is and apply it to our situation. We believe that this is covered by disability. In fact, the defendants are seeking to change the law by saying, well, we don't have to engage in that interactive analysis. Under this particular situation, we just don't have to do it. And I don't think that that's proper, Your Honor.
Okay, thank you.
Thank you so much.
Mr. Clarkson, good morning.
Good morning, Your Honor, Mr. Chief Justice. With me, Tay Phillips. We represent defendants below and appellees here. Your Honors, this act is a decriminalization statute only. And as such, and given that plaintiff Ms. Barbuto only asked that ASM entirely scrap its drug-free workplace policy as applies to marijuana, the court is under no obligation to find that she has a 151B action.
Well, wasn't that a cause of action that was alleged?
Which one?
Wasn't there a separate count for 151B?
Oh, yes, absolutely.
All right. So
and my
you're
point,
saying that was not adequately alleged?
My point is that this court can decide as a matter of law that the employer was within its rights to enforce its drug-free workplace policy, especially here, where plaintiffs' only requested accommodation is that a company scrap entirely its drug-free workplace policy as it applies to her. She has not asked, and she has been clear in her briefs, that there is no other accommodation requested. And so here, like in other courts that have found there is no requirement that an employer engage in that form of reasonable accommodation to waive its drug-free workplace policy as it would apply to a Schedule I drug banned for all purposes under federal law. If plaintiff had, hypothetically, asked for a different accommodation, right, take time off while she got off the marijuana, for instance, and I'm making things up that are not in the complaint, perhaps that would be different. But her only requested accommodation is that she be allowed to work and either not be drug tested.
Do you need to do that in order to state a viable claim for 12b6 purposes? Do you have to talk about precisely what accommodations would be reasonable that you want?
Well,
or do you have to simply make out the elements of a claim?
She has made absolutely clear here that that is her only requested accommodation. And based on those facts, this employer is within its rights to deny that accommodation. And this has been found by other courts. And an important thing to bear in mind here, Your Honor.
Before you get there, let me ask you about the the language in the statute that says something about on-site use, comparing on-site use to off-site use. So why would they put that in there if the legislature didn't imagine that it would be okay to use marijuana off-site?
Well, That is the only reference to employment in the
Right.
regulations, okay? That an employer doesn't have to accommodate on-site use. And the things that they list are fairly common sense in schools and prisons and the like. For this court to imply that means that off-site use is allowed, that's not required. It's not an absurd result that this statute only allows an employer to ban those sorts of on-site uses. And for this court to extend...
That kind of flies in the face of the normal rules of statutory interpretation. I mean, if they say we don't mean to prohibit on-site use, then it follows that they're not saying anything about off-site use. That's how we interpret statutes.
Let me make a legal and a practical point. The legal point is that same question has been addressed and found in what would be defendant's favor here in the Roe case in California, in Washington rather, and the Ross case in California. That same on-site, off-site issue has been addressed by those courts. And now the practical purpose. Plaintiffs would, to make sense of plaintiffs' argument, they have to imply all sorts of things into the statute that aren't there. For instance, well, this has to authorize off-site use when the statute doesn't say it. In fact, the regs say nothing in here should impugn the rights of employers. They also have to imply that, well, you can't be impaired at work. The statute doesn't say that. You know, and what is off-site use? Is off-site use on your lunch break? Is off-site use 10 minutes before you get to work? You can imagine the practical conundrums that this would put employers in, right? If you smoke marijuana in your car right before you get to work, that is off-site, but you're intoxicated at work. And they say, well, there's no protection for intoxication, but the statute doesn't say that either. And if you look at the chart that we have in our addendum, 11 states are very clear about this. They provide anti-discrimination protections for employees, and they carefully proscribe possession at work, use at work, or intoxication. The Massachusetts statute doesn't. Yes.
But that goes to whether or not there's a right of action under the statute itself. That doesn't really speak to 151B. And 151B, let's go back to the example that Chief Justice Gantz asked you to consider before, asked your brother to consider before, which has to do with not marijuana, but let's say a cancer patient who is taking an opiate. And the question was, first, can there be an employer policy against employees using opiates? Assuming the answer to that is yes, that doesn't answer the question if you have a disabled person with cancer whose doctor says opiates are the solution, and that person takes them, whether or not the employer has to make a reasonable accommodation for that disability.
There's a really important distinction that answers this question directly. 151B does not focus on treatment, and there is not a case in plaintiff's brief, MCAD's brief, or MELA's brief that addresses treatment, including Dayhill. 151B focuses on limitations. The Massachusetts Medical Marijuana Act focuses on conditions, ALS, Crohn's disease, cancer. So 151B requires an employer to look at an employee's limitations, and if they're significant enough, make reasonable accommodations. The Marijuana Act says if you have cancer or Crohn's or ALS, you can use marijuana. There's an obvious distinction.
What about the question? I'm not seeing the distinction there. I'm really not seeing the distinction.
I'll give a
there.
practical example of the distinction.
What about the opium example that I asked you about? What about the cancer patient?
Sure.
Does the employer have to accommodate that?
Cancer, let's take a cancer. Let's take a testicular cancer or ovarian cancer. Might impact your ability for reproduction. That's not likely to create a limitation that an employer has to accommodate.
How about...
But it would. Ms. Barbuto's example. She does not use marijuana for her Crohn's disease limitations, but to stimulate her appetite. That's what the complaint says. Is there an employer-based accommodation for stimulating her appetite? No, and that's the important distinction. So
but Crohn's disease has been recognized as a disability. They say, the MCAD brief says, that the employer needs to, if the employee presents with that, needs to, and needs reasonable accommodations in order to be able to deal with that disease, that the employer needs to accommodate them. That's how I read the MCAD brief.
Crohn's disease itself may get you a medical marijuana card. Crohn's disease itself is not necessarily, or in all instances, a 151B disability. 151B would say, does it have substantial impairment on a major life activity? If so, then an employer would address the limitations, not the treatment. So you wouldn't look at the the opiate use or the marijuana use and say the treatment is the accommodation. And to the extent
No,
that there...
but whether or not the person can engage in the treatment.
Right, and the MCAD cases that cite this go about this far. They'll say a schedule adjustment to allow somebody to inject insulin or the like, but it's not a wholesale elimination of a fundamental employer policy. And
As applied to that employee, it can be.
there's not a case out there that says an employer would be obligated to, for instance, scrap a drug testing policy.
As to that employee?
Correct.
Well, they could keep doing the testing, but the consequences of the testing would have to change.
That's the plaintiff's argument. There's no case that addresses an employee's treatment except to the extent of a schedule adjustment for the kinds of things, or conduct cases that the MCAD cites, for instance, about an employee with mania who may need a relaxation of a work rule. This would wholesale scrap an employer's pre-employment drug testing thing. And another practical thing that's important to pay attention to is marijuana testing now, and the technology, does not delineate between intoxication and past use. So you'd put an employer in an impossible bind.
How is that different than if somebody's taking an opiate? And the question is whether or not that impairs their ability to perform. You could presumably see the same thing if somebody's marijuana usage was impairing their ability to perform their job.
Two reasons. One is an opiate is not a Schedule I drug under federal law, which has no...
that's not the point, is it?
Well, the second thing is I think what you're now driving at, which is that the case law looks at the limitations of the employee, not the treatment they're taking. So if Ms. Barbuto said, I have the following limitations, given my Crohn's disease, I need to take more frequent breaks to eat to deal with my gastrointestinal issues. That's a different animal than I use the following medication to treat that. The cases don't address the treatment, they address the limitations. And conflating the two, plaintiff's brief, Crohn's disease required her to use marijuana. It absolutely did not require her to use marijuana.
Don't know
There's
that.
lots
You're not
of
a
treatments.
doctor.
No, but there are a host of treatments for Crohn's disease other
There are
than
a host
marijuana.
of treatments for cancer, and if the doctor provides an opiate for you to take, even though there may be other painkillers on the market, is the employer to say that?
No, but the employer's obligation under 151B is to address the limitations of the employee, not the treatment that they take. So if the limitations require a schedule adjustment to inject insulin or the like, that is a 151B accommodation. Scrapping wholesale a drug testing program is not.
Isn't this a summary judgment argument on what proper limitations have to be addressed? How can we do this on a motion to dismiss record?
You can do it on a motion to dismiss in this case.
Because your brief cites a study on treatment of Crohn's disease. That's completely outside the record. That's not part of the motion to dismiss record.
The reason this can be decided on a motion to dismiss is plaintiff has made absolutely clear that the only accommodation she wants and she requests is that she be allowed to fail the drug test and keep her job. She asks for no other accommodation. And just as the case, the courts, and I quote them at length in our brief, just as the courts in Shepard v. Coles in California, in Johnson v. Columbia Falls in Montana, Supreme Court, and Garcia v. Tractor Supply in New Mexico say, the request to use an illegal drug is not a form of reasonable accommodation as a matter of law. And
But I mean, okay, so let's imagine that somebody has a cancer condition which would otherwise put them in excruciating pain. They're taking pain medication which controls their pain. They are able to work only because the pain medication limits their pain. Is it your view that the employer can say, I am going to bar you from using that pain medication? Because if it is, my pain is too severe to allow me to work.
what an employer has to do is accommodate the limitations that come from the cancer. There aren't cases that address treatment. And furthermore,
the limitation is that the person can't work because they're in pain. I mean, that's an unreasonable semantic play on words, this distinction between limitation and treatment. Well, the limitation is I'm in pain because I have cancer. And the accommodation is I need to be able to treat my pain. So I don't understand why you're making that distinction.
The distinction's important, and the distinction's been adopted by these other courts that I just cited when it comes to marijuana. And to the extent that a non-Schedule I drug is treated differently, that's a legitimate distinction. But this is not one of those drugs.
But we've said that it's okay to use marijuana for limitations that a person may experience because of a certain described group of diseases.
Her only requested accommodation is not a limitation on her ability to work. It's that she wanted to be accepted from this drug testing rule as it applied to a drug that is illegal under federal law.
That's my point. It's a semantic difference that you're constructing here that doesn't make any sense. Her limitation is that she cannot work because she won't have the energy to work because she has Crohn's disease, which has all sorts of nasty things that go along with it. She won't have the energy to work if she can't eat. So I don't understand how that's a treatment issue rather than a limitations issue.
Let me just read you a short quote from how the Garcia court dealt with this, okay? Because I don't, the question implies that this semantic, this was a semantic thing that I came up with. Quote, testing positive for marijuana was not because of Mr. Garcia's serious medical condition, HIV/AIDS, nor could testing positive be seen as conduct that resulted from his serious medical condition. Using marijuana is not a manifestation of HIV/AIDS. You've got similar language and analysis from the Montana Supreme Court in the Johnson case, in Shepard v. Coles.
And this is interpretation of what? Their anti-discrimination statutes?
Their own medical marijuana statutes.
All right, so that doesn't have to do with a discrimination statute, does it?
Well, no, there are these same discussions have been held in the California FEHA, which is their 151B equivalent.
It's limited according to the MCAD.
Really the correct distinction, I think, to make is, and the medical marijuana statutes across the country do vary slightly, but the correct distinction to make is the medical marijuana statutes that contain anti-discrimination provisions. If you look, for instance, at New York, it holds that the statute finds that anyone who is entitled to a medical marijuana card shall be deemed disabled under the New York Civil Rights Law. Nevada law requires that employers specifically accommodate medical marijuana. That's not true here. We are one of the states, among many others, that have a decriminalization statute only. And plaintiffs' attempt to read these in harmony with each other fails because it's not the same definition of disability and medical marijuana card entitlement, because it would put employers, the court would also have to read into the law, well, you can't be intoxicated at work, you can't possess at work. Does off-site use include 10 minutes before or 10 hours before? None of this is stated. The only way to read this law reasonably is to find that it's merely a decriminalization law, which does not abrogate an employer's 151B obligations, but it should not require them to wholesale scrap a lawful and non-discriminatory.
Let me step back. Would there be any bar from an employer who says, I have a drug-free policy, but because you have Crohn's disease and because your doctor believes it's necessary for you to take it, we will, as an accommodation, make an exception for you and permit you to use medical marijuana? Is there anything that bars an employer from doing that?
No, and many employers don't drug test at all.
And isn't that what, according to the complaint, that is what her supervisor did initially?
According to the complaint, she worked for a day before the drug
which
test results came back.
According to the complaint, which we have to accept as true for purposes of motion to dismiss, the employer effectively said, we have this policy, but we will permit you, because of your medical condition, to use marijuana because the doctor has prescribed it and because you appear to need it. And in reliance upon that, she did, and then you fired her. Is there not a problem with that?
I don't think that converts this drug test from anything other than a pre-employment drug screen. It doesn't make it a de facto random drug screen that carries with it the additional privacy rights.
Okay, isn't there an obligation under those circumstances to say, it turns out that actually the reasonable accommodation we had granted you earlier, we are no longer going to grant you, so let us now see if there is another way in which you can provide medication which would not be in conflict with our policy, and discuss that with her before you fire her? Would that not be your obligation under 151B?
The only case that's really analogous to that hypothetical, I think, is this Coles v. Harris-Teeter case that plaintiffs cite. And that case is really different in that there was evidence that the employer had previously exempted someone who had tested positive for cocaine and not enforced their drug testing policy uniformly. There's no evidence or even allegation here that the employer did that.
Of course it is. Wait. The complaint says, the supervisor said, it is okay for you to use medical marijuana, and that we have to accept as true. And then she received a drug test, and then that supervisor's determination was apparently overridden, and without warning, without notice, as alleged, you fired her for using the marijuana which that supervisor said she may continue to use.
To the extent you're driving at a 151B point here,
Of course I am.
The employer also hired her after her disclosure of Crohn's disease, according to the complaint. So the idea that they were motivated by a disability bias fails on the face of the complaint. She says she has Crohn's disease, is hired, fails the drug test, and is then fired. It wasn't the Crohn's that was the issue by the face of the complaint. It was the failed drug test and the failed drug test alone.
She disclosed that she was using the marijuana before she was hired.
And disclosed that she had Crohn's.
Right, and there was a connection drawn immediately between the two. It's not like she had Crohn's disease and,
Agreed.
oh, by the way, I also use marijuana. It's, I have Crohn's disease and I use the marijuana to deal with the Crohn's disease.
That's right.
Is that going to be a problem? No, is what the complaint suggests.
It does, and then they get back the pre-employment drug screen, which fails her for marijuana, and she is terminated per the terms of the company's
But
drug testing policy.
the drug-free policy, the purpose of it is not to test and see who comes up positive and who doesn't. The reason for the policy is to make sure that people are not abusing drugs, not using. It's abusing. And so I don't know why you think this would undercut the policy where somebody is using a drug, for a medicinal purpose. That's entirely different from a person who uses it for recreational purposes. That's the kind of thing that's the focus of the policy.
I think that underscores our point, Your Honor, and here's why. The drug testing out there for marijuana does not distinguish between intoxication and past use. So an employer is in no position to be able to determine whether somebody's intoxicated at work when they get a drug test result back. So that's why they have to rely on the technology that they have.
But they're presumed to be if they don't have a prescription to use it. The presumption is that they don't have a right to be using it and to keep their job.
But counsel would say, you know, Ms. Barbuto will not appear at work intoxicated, right? But how is Advantage Sales and Marketing ever to determine that on the technology that we have now? All we have is a positive drug test result of so many nanograms per milliliter. And the statutes that do create job rights, the 11 that I lay out in this chart, they specifically carve out intoxication at work. This statute does not. And for this court to impose the rule that plaintiff would have, you would not only have to imply a job right, but you'd have to imply all of these other restrictions, which aren't in the statute and aren't in the regs. You can't possess at work. To the question earlier about federal, the Federal Department of Transportation, DOT regs, or NRC, Nuclear Regulatory Regs.
Well, how
FAA.
about Justice Gaziano's general point? His question to the appellants about federal law in general, without getting into the various federal agencies. What's your response to the appellant's answer to Justice Gaziano?
Right. There are all sorts of federal laws that would restrict and prohibit the use of marijuana. And the law is, of course, because in our view it's a decriminalization statute, silent on those. If you give the plaintiffs what they're asking for here, it would leave employers in a conundrum. Well, we have DOT drivers. What are we to do?
Are you saying that there is a law which says that it is illegal for an employer to hire somebody who has used marijuana?
The DOT regs have a...
You're not DOT. This is not, I mean, you're not within the DOT regs, are you?
No, we are not. We are not.
Okay, so I'm referring to an employer who is not within the context of federal regulations. I'm referring to your company. Is it your view that your company is at any legal risk if it were to employ somebody who has used or is using marijuana?
No, we are not at legal risk of federal regulation, but if the court were to extend this, an employer who is would have no way of knowing, unless this court implies all sorts of other regulations which aren't in the law, where the parameters are. It would be a practical, and for the years it would take the cases to develop, it would require employers to just decide we
For all
couldn't test.
reasonable accommodation cases, that it's on an individualized basis and they get duped out in the courts?
Except here where plaintiff says there's only one accommodation I want, and that accommodation is unreasonable.
Well, you're saying it's unreasonable.
And
that's
there are
certainly not
plenty of other
something
courts and
that-
other jurisdictions who have said that too. Plaintiffs can't cite to a case. This is all
But
brand
this
new.
is, the MCAD is not saying that it would be categorically unreasonable.
But the MCAD cites to no cases
Does it
that
need
talk
to?
about treatment.
Does it need to?
Yes, because the difference here...
From other
treat-
states? It needs to cite to cases from other states?
Oh, I misunderstood your question. They can't cite to a case that discusses the treatment of limitations. The cases on 151B are about the nature of the limitations, not the nature of the treatment. And if we start down the road of can you treat here with this, it's an entirely different paradigm. Getting a marijuana card may overlap with being disabled, but it's not synonymous.
Okay, thank you.
Thank you.